Hello, and welcome to the Public Justice Center's presentation on the settlement in our recent lawsuit, Gorres v. Robinson, which seeks to address system-wide challenges and failures in Maryland's unemployment insurance, or UI system, and make it stronger for workers. The settlement went into effect on December 7th, 2022, and it'll remain in effect until June 7th, 2024. This means that if there are widespread violations of the settlement during that period, we as attorneys can get back to court and get the state to comply. Today's presentation will explain each element of the settlement and how you can help us to monitor compliance. Let's begin with the elements of the settlement. First, the settlement requires the state promptly process initial or new claims for unemployment insurance. Specifically, the Maryland Department of Labor must issue payment or a written denial, which can be appealed, on 92% of all new claims within 21 days of when they're filed. And the department must issue payment or an appealable denial on 97% of claims that require a hearing or adjudication to resolve a factual dispute within 8 weeks. In short, if you apply for unemployment insurance for the first time, you no longer will end up waiting for several weeks or months for any kind of response on your claim. You'll get paid, or you'll get a decision explaining why you're not eligible for benefits, which you can then appeal. Now, when is a claim considered filed? It used to be that UI applicants would essentially have their claims sitting without response or resolution for weeks because they'd made minor technical errors on the application. For example, they may have uploaded a photo of a document that didn't show all 4 corners of that document. But under the settlement, the Department of Labor must consider a claim filed and must stick to the timelines we discussed with respect to those claims at the point that an individual submits it on Beacon or by telephone and mail to the department. The department might ask them to correct technical errors, but it can't delay processing the claim because of them. And the remaining 8% or 3% of claims that might not be resolved in the established timelines will get extra attention from a UI ombudsman whose job is to ensure that lagging claims are processed as quickly as possible. Anyone whose claim has been pending for more than 21 days can contact that ombudsman directly to get help. The settlement also ensures that once a UI applicant is actually receiving benefits, they'll continue to receive those benefits as long as they keep filing weekly certifications that they're still unemployed, without any long suspensions of benefits. When someone who's applied for UI benefits begins receiving those benefits, their UI claim is called a continued claim, and they are a continued claimant. The claim will get paid each week after the applicant certifies that they're still unemployed. The settlement provides that if the Department of Labor has some concern that a continued claimant is no longer eligible for benefits, they can pause payment on the claim to investigate, but only for a maximum of 14 days. At the end of 14 days, the department must either resume payment or issue a denial of benefits explaining why the continued claimant is no longer eligible, which the claimant could then appeal. Bottom line is that once you start receiving UI benefits, you should keep receiving them. It should never experience more than a 2-week delay in payment unless the department issues an appealable written denial. Our understanding is that the department has updated its Beacon claims processing portal to ensure that this happens automatically. The settlement also makes changes to ensure that UI claimants have a fair opportunity to participate in interviews or hearings to demonstrate that they're eligible for benefits. And it seeks to ensure that these proceedings are conducted in a way that's fair to UI claimants. In some UI cases, there's no major dispute, say between the UI applicant and their former employer, about whether the employee was actually laid off and is eligible for benefits. In these cases, the department doesn't need to do anything beyond a short interview with the applicant to gather or confirm basic facts. In these cases, under the settlement, claimants are entitled to 1. A reasonable opportunity to reschedule if they or if their attorney is unavailable. 2nd, the department has to try to reach the claimant in all ways that they reasonably can. So instead of just via beacon, by beacon and phone and email if the claimant has provided that contact information. And 3rd, the department has to give the claimant a reasonable opportunity to establish their eligibility. The department can't rely solely on a computer database, say of folks who are currently working, to conclude that an individual is ineligible for unemployment insurance benefits. Instead, the department has to give the individual a chance to show that the information in the database is not accurate. And if the department suspects that the claimant is ineligible, they have to present the information indicating why that is and allow the claimant to respond to it. In cases where there is a significant dispute over whether the individual is eligible, there might be a need for what's called adjudication, essentially a hearing where the individual and their former employer are on opposite sides and get to present their evidence or arguments for or against eligibility. Here too, the claimant is entitled to notice of all the details of the proceeding and a reasonable opportunity to reschedule. And if it's a telephonic hearing, the department can't just call once and if the claimant doesn't pick up, conclude that they failed to appear. That's something we know has happened to UI claimants in the past, but the settlement requires at least a couple of attempts at the scheduled date and time of the hearing before concluding that a claimant has not showed up. UI claimants should also get adequate notice of these interviews and hearings, and we'll talk more about notice later on. The settlement also makes clear that UI claimants have the opportunity to file an administrative appeal with the lower appeals division and then the Board of Appeals in every instance where their benefits are denied or terminated, or where they are being issued an overpayment and asked to repay benefits that they've already received. Essentially, claimants can get a higher level decision maker to decide whether a denial of benefits was right or wrong and reverse the denial if it was wrong. It used to be there was not necessarily a clear way to appeal monetary determinations that denied benefits. A monetary determination denying benefits is where the department issues a denial because it thinks that the applicant doesn't have enough quarters of work to qualify for unemployment insurance. But the settlement makes clear that these are in fact appealable, just like other denials and terminations of benefits. At the same time, since questions about whether monetary denials are correct can often be resolved fairly quickly, the settlement includes an informal process prior to an appeal where the applicant can just get on the phone with someone at the department to try to sort things out. It might be simply a matter of a document that was missed. But if the claimant isn't getting a prompt resolution or is unsatisfied with that informal process for any reason at all, they can just stop and ask for an appealable determination at any time and go the appeal route right away. Overpayment determinations were another type of decision that prior to the settlement were not clearly appealable. We heard from UI claimants who suddenly saw overpayments show up in Beacon and had their benefits deducted or tax refunds intercepted even though the department hadn't contacted them to try to find out whether the benefits had actually been overpaid. And once that happened, they typically had no way to file an appeal. The settlement aims to change that. Under the settlement, the Department of Labor has issued new regulations at COMAR 09.32.12 that require the department to conduct a thorough investigation before issuing an overpayment determination. Again, that investigation looks different if there's no dispute that the individual was overpaid versus if there is. If there's no dispute, then the department simply interviews the UI claimant to get information pertinent to whether they might have previously received benefits that they weren't eligible for and therefore were overpaid. As before, the department can't just rely on some automated database alert to conclude that there was in fact an overpayment and has to make all reasonable efforts to contact the claimant, present them with the evidence that suggests that an overpayment occurred, and allow them to respond. There is a dispute. Then there would again be a two-party hearing, and the claimant would have notice of when and where and how that hearing would go forward, and would be entitled to present evidence and dispute the evidence on the other side. After this investigation, whether it's a hearing or an interview, the department could either decide that there isn't enough evidence that the benefits were overpaid and not make an overpayment determination, or it could decide that the evidence supports issuance of a determination. If it does that, then the overpayment determination has to clearly explain the basis for the overpayment, both legally and factually, and the claimant's right to appeal the determination or to ask for a waiver so that they're excused from having to pay back benefits, even if in fact the benefits were overpaid. The notices also can't include any accusations or scary language around benefits fraud unless the department has actually gone through a process and determined that the claimant committed fraud. And all of these notices related to overpayments must be delivered by first-class mail, potentially in addition to another method. We'll talk more about the notice delivery piece later. If the claimant still thinks that they weren't overpaid, they can then appeal that determination to the lower appeals division, and again, subsequently to the Board of Appeals. And they'd once more have the opportunity to demonstrate that they were eligible for all the benefits that they got. The next element is about overpayment waivers. A claimant might ask for an overpayment waiver if they don't disagree that they were paid more in unemployment benefits than they were actually eligible for, but it wasn't their fault, and they feel it would be unfair or burdensome to have to pay back the benefits that they'd previously gotten. The first critical point is that the department, as part of the settlement, is going to look back at every case in which a UI applicant paid back an overpayment issued any time in the last 3 years, and they're going to issue a retroactive overpayment waiver if the claimant is eligible for what's called a federal blanket UI overpayment waiver. Federal blanket waivers are available in certain situations where a claimant was getting federally funded UI benefits like PUA or PEUC or other pandemic-era UI benefits and was overpaid as a result of a mistake by the agency. Specific examples are listed here on the slide. So if this applies, the UI claimant would actually get back their money from the department without having to do anything on their own. Regarding the process going forward, the department has adopted new regulations on overpayment waivers. Denials of requests for waivers may be appealed, again, to the lower appeals division and then the Board of Appeals in 30 days, and claimants can appeal the underlying overpayment determination at the same time that they appeal the denial of the waiver. So essentially, they can simultaneously file an appeal arguing that the overpayment is incorrect and they were actually eligible for all the benefits they received, and a second appeal that says even if the higher level appeals division concludes that the benefits were overpaid, the claimant should be excused from having to pay anything back because that would be unfair or overly burdensome for them. And the department cannot make the claimant pay anytime one of these appeals is pending. The settlement also includes some provisions to make Beacon work better. Prior to the suit, we'd heard from claimants who'd had notices or information go missing from Beacon or get deleted. That shouldn't happen anymore. And although the Beacon mobile app won't have all the same functionality of the desktop version, it will alert users to its limitations so that they know when they either need to get on the desktop version to do what they need to do to handle their claim or to call the department to handle the claim by phone. The department will also be more transparent about the option to apply for benefits and manage all aspects of a claim by phone. The call center will also be more effective going forward. Claimants should not experience calling and being told by staff that they can't handle their request or need to refer to someone else, because call center staff will be trained and authorized to handle all claim management functions. They'll also be able to connect new applicants with the UI Ombudsman if their application hasn't been processed within the timelines we discussed earlier, within those 21 days. All UI decision notices will have standardized language that will explain the legal and factual reasons for the decision, explaining exactly how to appeal, and the notices will not reference fraud unless there's been an actual finding that fraud has occurred. Now, how will notice be delivered? The department will continue to give people the option to select first-class mail, email, or text. But they'll be clear up front they can always change your preferred notice method. And if you do choose email or text, it'll be clear that you won't be getting the substance of the notice in that email or that text. You'll just be getting a notification through email or text to check for notices in Beacon. It'll also be very clear that if you opt for the text or email method, you won't also be getting notices by regular first-class mail. Again, the claimant would have the opportunity to change their delivery method at any point. Now, there's one exception to the last piece about claimants who select text or email notification not typically getting an additional notice by regular mail. Overpayment-related notices, so determinations of overpayments or determinations or denials of overpayment waiver requests will always come through regular mail in addition to email or text if the claimant has selected one of those options. What this means is that if someone is no longer receiving UI benefits, they're not having to monitor Beacon months down the road in case an overpayment determination is issued. All of the processes and procedures and timelines for processing new and continued claims that we've discussed apply even if there's suspicion or a flag for fraud on a particular claim. Claimants can no longer be indefinitely locked out of Beacon because there's a fraud flag on their claim. Instead, the department has to investigate and decide the claims within the required timelines, and they can only reference fraud in any denial or termination notice if they've actually found it. And that denial and the fraud finding would themselves be appealable. So now we're going to talk about how you can help us figure out whether the state is complying with its obligations under the agreement. If there's a pattern or practice of violations, that could be a basis for going back to court and seeking an enforcement order. So let's talk through the red flags to look out for. They're all on the slides, but I'll try to hit just the high points. First, non-isolated timeliness failures. We're talking about failures to process new claims within 21 days or to resume payment or issue denials on continued claims within 14 days of a suspension of benefits to facilitate an investigation. Also talking about situations where UI claimants have been receiving benefits but then get locked out of Beacon and can't get those benefits for more than 2 weeks. Again, that should not be happening. A second type of red flag or violation would be where folks are not getting sufficient notice of fact-finding interviews or hearings or a reasonable opportunity to reschedule. So for example, a claimant gets notice that they failed to appear for an interview or hearing, but they never found out about that hearing in advance. The third set of problems are problems with content and the delivery of notices. If claimants see notices that warn them about penalties for fraud, where there's been no finding of fraud in a written decision, that's a violation of the settlement agreement. Or if claimants don't actually get notice by text, email, or regular mail, if they'd selected one of those options, or if people are unable to change their method for notice delivery. A fourth set of potential violations relate to appeals. Anytime a claimant is unable to appeal a decision that denies or terminates benefits or issues an overpayment, that's a concern. The appeal button should always appear in Beacon when such decisions are issued. And with respect to the informal dispute resolution we talked about for monetary determinations, claimants should always be able to immediately get an appealable determination if they ask for one. If that does not happen, if they're forced to proceed through the informal process after they've requested an appealable determination, that too is a concern. Fifth set of potential violations relate to the overpayment process. These include situations where the claimant isn't contacted and invited to participate in an investigation of a possible overpayment before an overpayment determination is issued. It also includes scenarios where a claimant gets an overpayment that they're allowed to appeal, but then they're told that they can't make the argument that they were eligible for all the benefits they received because there was some previous determination of ineligibility that they failed to appeal earlier on. The claimant who gets the overpayment should be able to appeal all the substantive issues related to that overpayment together. It's also a problem if a claimant is told that they have to choose between appealing an overpayment, challenging whether it was right or wrong, and asking for an overpayment waiver. They should be able to do both at once. And finally, if a claimant sees that the department is reducing their benefits or otherwise trying to collect on an overpayment while their appeal or waiver request is pending, that's a violation. A sixth set of red flags relates to overpayment waivers specifically. For anyone who is getting PUA or PUC or maybe MEUC and who got hit with an overpayment, there's a good chance that that claimant is eligible for a retroactive waiver. So if the claimant already paid back the overpayment, they probably should be getting a refund from the department. If there are folks in this boat who do not get a refund, we'd encourage them to contact us because it might be that they were eligible for a blanket waiver that they didn't get. Seventh, it is definitely a red flag if Beacon crashes and doesn't come back up promptly, or if claimants are unable to manage their claims effectively by telephone during any period that Beacon is down. Again, please do contact us if that happens. Here's the last set of items to be on the lookout for that might reflect violations of the settlement agreement. No one should be told that their claim can't be processed until they fix technical errors, like a photo not showing 4 corners of a document. The claimant now might be prompted to correct the issue, but the department needs to move forward with processing it on the regular and established timelines. If claimants can't effectively use the phone as an alternative to Beacon or manage claims to prove identity, that's a problem. And if it takes hours to get through to customer service to deal with claims management issues or questions, or if customer service staff simply aren't able to answer those questions, that's another consideration that might suggest a violation. Now, looping back to what I said at the beginning, isolated failures will happen and they might not amount to a violation of the agreement. It's really a question of whether something is happening on a system-wide basis. That said, we recognize that individual claimants or their representatives won't know necessarily if an issue they're experiencing is isolated or not. So do err on the side of contacting us if you experience a problem, and we'll go from there. Note that we won't be able to represent folks on problems with individual UI claims, but we can refer for legal representation while at the same time gathering information about whether the problems reflect broader systemic failures. We'll close by saying that if you are experiencing a problem with unemployment insurance in Maryland that might violate your rights under the Gorres v. Robinson settlement, please complete the Google form on the Public Justice Center webpage where you accessed this webinar. We will review your information and be in touch about next steps. Thank you so much for listening.